The Minnesota Supreme Court heard arguments on November 30th on an attempt by environmental groups in Minnesota to cancel a key permit for the long-stalled PolyMet copper-nickel mine here in northeastern Minnesota. Opponents of the PolyMet project say that state regulators should have included end-of-pipe limits on discharges of mercury, sulfates, and other pollutants in the water quality permit. They also say the state improperly tried to suppress the concerns of the Federal Environmental Protection Agency during the permitting process. One of the people that presented during the November 30th hearing in front of the Minnesota Supreme Court was Paula Maccabee. She is the Advocacy Director and Legal Counsel for Minnesota-based WaterLegacy. She joins us now again on WTIP. Paula, thanks for your time.
Thank you for inviting me, Joe. Really appreciate it.
All right. Well, if you can, please summarize what was presented from you and attorneys for Fond du Lac and others during the hearing on November 30th and what comes next after that.
Well, let me give you a quick summary and then you can ask me more detailed questions. I went first, and what I emphasize is that the Minnesota Pollution Control Agency acted in an unlawful, arbitrary, and capricious manner, not just to convince EPA not to send its comments and thus allow the MPCA to circumvent the protections that are in Minnesota's law and in the Clean Water Act about making things public and having the agency respond to the EPA. But as a result of that, there was nothing in the record expressing EPA's concerns that this permit, that the North Met water pollution permit, would violate the Clean Water Act, violate Great Lakes laws, and would be providing inadequate protection for clean water and aquatic life and human health due to the absence of end-of-the-pipe limits on pollution based on Minnesota water quality standards. So that's what we argued. And then the Fond du Lac Band Council explained that their standards for the downstream reservation are even more stringent than Minnesota's state standards. And the Minnesota Pollution Control Agency completely ignored them, even though the EPA comments, once again, the secret hidden EPA comments, emphasized that the permit had to comply with the laws of the downstream state. And then Evan Nelson for the conservation organizations brought up another issue, which is based somewhat on the Supreme Court's decision in the recent case of U.S. Steel, which, WaterLegacy and the band also participated in. And that's that if you read Minnesota groundwater rule strictly, which is what the prior case from the Supreme Court said to do, then having a tailings basin and a waste rock pile that just dumps the pollution into groundwater is not allowed, that one has to use the best available technology or get a variance. And the Minnesota Pollution Control Agency didn't require PolyMet to take either step. So what we're looking at with the argument before the Minnesota Supreme Court on PolyMet's water pollution permit are three big issues. One, is the court going to hold the Minnesota Pollution Control Agency accountable for improper and unlawful procedures and make sure that processes are done correctly? Number two, is the court going to require end-of-pipe limits like are done for all other permits and like the EPA said were absolutely necessary to protect human health as well as water? And three, is the court going to hold Minnesota to its laws, which provide very strict protection of groundwater by the actual terms of the rule? So those are three really big issues that have implications, I would say, far beyond the PolyMet case, both for regulatory integrity and for Minnesota clean water.
Well, you've said in the past on WTIP, Paula, that if we can't trust the agencies that are in charge of regulation, and in this case, this instance, the Minnesota Pollution Control Agency, then the whole process needs to be redone if we can't trust the organizations. When you talk about setting a precedent and that this moves beyond just the PolyMet hearing, is that what you're referencing, is the fact that the MPCA essentially engaged in some improper conduct, is I believe a term that you use, when it came to the concerns of the EPA, that this is a bigger issue than even just the PolyMet situation?
This is a really big issue. This is actually the first time in Minnesota history that any court has found that an agency engaged in irregular procedures and unlawful procedures under the Minnesota Administrative Procedure Act with the motivation to circumvent public access to information, circumvent the press, circumvent public accountability, and even circumvent the Clean Water Act requirements that if the EPA comments had been in the record, the Minnesota Pollution Control Agency would have had to make responses to them in writing. And this is so important because if we can't trust our regulators, if they can get away with it, that means we really can't trust the permitting outcomes, not just in PolyMet, but in all kinds of other cases where Minnesota regulators have to decide under what conditions developments can take place.
When this surfaced about the concerns that the EPA had and the fact that MPCA improperly tried to suppress those concerns, that came about through whistleblowers within the agency as well as freedom of information requests that were made. Without those, would this never have been brought to your attention, to anybody's attention for that matter?
You know, Joe, I think when I think back of it on it, I think how many people had to work together to even get this secret out. And let me explain a little bit. WaterLegacy heard from one of our tribal contacts that there was something fishy about EPA. That's all we heard. And so right after the public comment period closed, we began the first of 7 State Data Practices Act requests and 9 Freedom of Information Act requests. And then as we began to get information, there were some sort of hints in the notes that one of the staff members took, but we couldn't make sense of them. And then what we ran into is an absolute wall in terms of getting documents out of the EPA. And we ended up having to take them to court not only once, but twice. And it wasn't until more than a year after the comment period closed and months after the permit was issued that we were finally able to confirm that there were EPA comments that were not submitted. They were in writing, they were in detail, they were not submitted, but also that the EPA read them to the Minnesota Pollution Control Agency. And so that was the first step, is getting that. And then the second step was there was a leak to the press that showed the emails from MPCA to EPA showing that it wasn't just EPA deciding on its own whim not to send comments, but there was an actual campaign, first time ever this has ever happened in Minnesota or anywhere in Region 5, where a state said, we know your comments are coming. We think they're going to be bad. Don't send them. And so we got that document. Part of it was leaked to the press, and then we did another FOIA lawsuit and got that document. And actually, until the Court of Appeals allowed this case, only the second time in history, to be transferred down to a district court for hearings to find out really what had happened, to do an investigation. And it wasn't until, 2 years after the permit was issued, after several motions by WaterLegacy and our allies to that district court, that we finally got notes written by an attorney within MPCA that showed in detail that EPA had read the entire comments, and so Minnesota Pollution Control Agency knew their concerns, knew they were objectionable, knew the legal citations, and yet they didn't put a word of that into their findings or their public record. So I think without courageous whistleblowers all along the way, and without the Freedom of Information Act and 2 Freedom of Information Act lawsuits, and there's an organization called PEER, Professional Employees for Environmental Responsibility, that did that litigation for free. And without the court process and this judge allowing us to see these internal attorney notes, we would have never gotten the full story. Because not only did the Minnesota Pollution Control Agency persuade EPA not to send its comments, they deleted all of their emails that to EPA having to do with that issue. Everything was gone. It was scrubbed from MPCA files. And the only reason we know about it is because of the whistleblowers and the fact that EPA did not throw out their email. It was a pretty long road, and there's no way to guarantee that next time around, if an agency engaged in similar shenanigans, they'd get caught. So the courts are really important in saying, no, you can't do this.
In the lead up to the hearing on November 30th, I saw a statement you released that said, the case is important because both whether the courts will help us defend clean water and human health and whether the courts will help us defend regulatory integrity in Minnesota. Based on the exchanges you had with the Supreme Court justices, do you feel you were heard, that will be taken into consideration, those key factors?
It was a very good hearing at the Supreme Court. I felt that they had read our briefs and that they understood the issues. We got a number of the different justices asking questions, so it was not a one-sided discussion. It's not possible ever to predict what a court is going to do, but I do believe that the court is looking seriously at the arguments and the facts raised by all parties. So we'll just have to wait and see. It's not something that, the court does not show its hands, and I'm not going to pretend I have the answer. But I think your point is really well taken, that regulatory integrity matters, because even though we were able, WaterLegacy, the Fond du Lac ban, the whistleblowers, the retired EPA attorney, we were able to get to the bottom of this situation with the help of the Court of Appeals and the judge in the district court. That won't happen every time. We really need to trust that the agencies will do their jobs without us having to spend 3.5 years trying to get it done right.
Well, PolyMet continues to move forward with their ideas to have a copper-nickel mine, including a merger with Teck Resources in 2022. It's a big development that could be a long play move. I know we're talking about the court hearing from November 30th, but any thoughts about that, Paula?
Well, Joe, I think this is another issue, I think, of importance in terms of regulatory integrity. What PolyMet is now proposing to do is to massively increase not only the size of the mine, but the amount of processing and waste storage and tailing storage. And many of our environmental groups raised that possibility in 2013 when a report written for PolyMet basically said, the only way this is going to be economically profitable for you is if you process and store the waste for other mining entities or other mines beyond your scope. And so we raised that in the environmental review process. And what the agencies did, they basically said, we're going to allow PolyMet to define what impacts we look at. We're going to allow PolyMet to ignore the impacts of future expansion, and we're not going to consider what they called then the tech project, even though they said in the final environmental impact statement they had information about it. And so this is a big concern. The actual mine that PolyMet is saying that they were going to include as the quote-unquote Mesaba project, that mine will pollute the Boundary Waters watershed. And if the plans come out the way we think they are, that PolyMet, once again, they're not showing all their cards, the processing would be at the old LTV site, and the processing and the tailings would impact the Lake Superior watershed. So basically, this possible expansion, and the most recent documents just came out November 28th, and I haven't read them all, but this possible expansion really is a danger both to the Boundary Waters watershed and to the Lake Superior watershed. And PolyMet was allowed to file its permit without ever having anyone look at what the combined effects or the cumulative effects would be of this expansion, which many of us believe was in the cards from the beginning.
Well, Paula, every time it seems like now that we have one of these conversations, I hear from listeners afterward who say, well, if we aren't going to get these minerals and metals, precious metals for the renewable energy that need to be had for electric vehicles and renewable energy and so forth, if we're not going to get them here in northeastern Minnesota, where are we going to get them? Let's just add that question in because it's something we hear from listeners after a conversation like this. What would your thoughts, or how would you respond to that, Paula?
Well, the first response I would make is that nothing in the record for the PolyMet project suggests that it has anything to do with providing essential minerals for EV. And PolyMet is a low-grade, what they call a disseminated copper project, which means that there would be an absolutely enormous destruction of wetlands and peatlands and the landscape for a relatively low percentage of copper. And the other question I have is, if we're at the cusp of development of battery technology, and most of the scientists are saying that lithium-nickel batteries, once again, PolyMet is a very low nickel resource. Lithium-nickel batteries are the most toxic, the most volatile, and that other forms of batteries are likely to be safer, less toxic, more economical. Why are we making the enormous risk of water and landscape and the ability to sequester carbon for a technology that is unlikely to be the long-term solution for anything? So I think if PolyMet never argued and still doesn't argue that any of the damage that would be done to northern Minnesota would benefit renewable energy. And if we look at the PolyMet project from A to Z, what we see is it's a low-grade deposit. It is done with the cheapest possible technology. There aren't even liners underneath its waste. And so what we have to say is, if PolyMet is now saying that there's so much demand for copper and nickel, well, then maybe they should redo all their plans and all their application to take advantage of what is available as the best available technology, because they sure as heck have not offered the state-of-the-art for anything that they are planning to do in northeastern Minnesota.
We appreciate you making some time for us on WTIP. We're speaking today with Paula Maccabee. She's the Advocacy Director and Legal Counsel for Minnesota-based WaterLegacy. Thank you, Paula.
Thank you so much, Joe. Really appreciate having a chance to talk with you again.